So today we will take up our next philosopher, important philosopher. I think we have already started this fella. It's Jeremy Bentham. Bentham on legal positivism. Just a second, let me. So in the last class, I remember discussing, his two different kinds of jurisprudence that he refers to. Okay, do you guys remember the two different jurisprudence that Bentham talks about?
Yes, sir.
Yes, sir.
Yeah.
Sensorial and
The
expositorial.
expositorial and the sensorial.
So what's the difference between these two? Some other student, not you two. Some other student. What's the difference between these two? Okay. Yes, Sanskar, tell me, what's the difference between expositorial and sensorial jurisprudence? Sanskar. Sanskar Pandey, am I audible? Swaswata. Am I? Okay, so can you type it, Sanskar? The difference between expositorial and sensorial jurisprudence. Okay, it's okay. Leave it. I will not complete the syllabus if I. There is nothing to remember. There is everything to understand. Try that. Anyway, I don't know if there is any point even repeating this because he will not remember anyway. So yes, expositorial jurisprudence is the legal positivism that Bentham develops, whereas his sensorial jurisprudence part is where he talks about his principle of utility and utilitarianism. And I mentioned two books. Okay, the first book that he wrote is An Introduction to the Principles of Morals and Legislation, is the one in which he talks about principle of utility, and then the other one of laws in general, which was later on published as the, what's the book's name? That we use
The
for
limits of jurisprudence determined.
Limits of jurisprudence defined. Okay.
Defined.
Okay. So that's the book, also known as Of Laws in General, in which he talks about positive law. So essentially, his idea behind writing this book, second book, which was discovered only in the 20th century, was that he didn't have good opinions about common law. He didn't like common law. This is something that we already discussed. Okay, he thought that common law was unpromulgated. Okay, that judges decided matters in every single case, so no one can know exactly what the law is. So there is lack of clarity. Prospectivity isn't there either. Okay, and it's uncodified body of rules which are not worthy of being called law for the said reasons, as I told you. So he was in favor of codified laws. So he took up this entire burden of defining what law, whether it is law is. Okay, he is not telling you what law is, because if that's what he was doing, then he would essentially be giving you a description of what laws are in England, but he's not happy with that. So he's essentially telling you what laws, what should be laws. Okay, so he's telling you that the codified laws are the laws. Okay, he's also giving you definition of what is law. Okay, but then we saw that, okay, before we go into discussion of law, we know that when laws are to be made, the legislators are to do the same. Okay, based on his principle of utilitarianism. So it should be based on utilitarian moral philosophy. So that's the idea, that If at all you want to reach something called justice, that you can do by using this principle that he talks about. Anyway, without going any more into what is utilitarianism, which we will discuss later on if we have time, let's look at what Bentham has to say about law. Okay. Now, Bentham uses the term law in two different senses. Okay. You can generally use the word law to refer to the phenomenon called, law. Okay. And then you can also use a law, okay, which means law relating to something. Okay. So it's more specific. Okay. So when he says law generally, it's generally an instrument, okay, for utilitarian reform. Okay, that's the general idea of law. What is law? We use law to reform, okay, using utilitarian principle. Okay, so utilitarianism, okay, it's a simplified science of law. Okay, and which is something that can create conditions for modern orderly society. So here he has some kind of value judgment. So here when he's talking about law generally, he's saying that it is something that you can use to create a modern orderly society rather than one that is struggling with metaphysics and all other nonsense. Okay, so that's generally his position about law. And then he talks about a law. Okay, so as I said, okay, what is a law? He's talking about here, his definition is kind of what ought to be law. Okay, but nonetheless it's a positivistic definition. So how does he define that? So he says a law as an assemblage of signs. Okay, so it's an assemblage of signs. Okay, so remember, unlike Austin, who merely says law is the command of the sovereign, his definition is not that simple. Okay, not that straightforward, because law itself is very complex. So it cannot be merely a command of the sovereign. But before even Austin simplified it, he had already given you a very deeply thought definition of a law. He says a law is an assemblage of signs. Okay, so not just one sign, two signs, but it's an assemblage of signs. So you find a law not just at one place, but at many different places. So he says a law is an assemblage of signs, declarative of the volition. Okay, volition means will. So he says what is a law? It's an assemblage of signs. Of what signs? Signs that declare the volition or will, okay, which is either conceived. When I say conceived, it's basically creation of the sovereign here, okay, or adopted. Sometimes it is not necessary for a sovereign to just conceive something new. It can also adopt something that already existed, or can say that whatever someone does will be adopted. Okay, so that's what the definition is so far. So it says a law is an assemblage of signs declarative of a volition conceived or adopted by the sovereign. Okay, so we need to define what sovereign is. Let's look at what it is in subsequently. In a state, so you need a state and then you need a sovereign, then you have what is known as a law. Okay, now what is this law about? So it further says concerning the conduct to be observed. Okay, so law is directed towards the conduct of persons. So concerning the conduct to be observed in a certain case. So yes, law is applicable in a certain case, okay, in a certain fact situation. So it's saying concerning the conduct to be observed in a certain case by a certain class of persons. That class of persons could be the entire citizenry or it could be individuals, okay, does not matter. So it's saying to be observed in certain case by a certain class of persons who in the case in question, okay, in this specific case, okay, the fact situation that we just discussed, okay, or are supposed to be subject to his power. Okay, so he's saying that they either are or are supposed to be subject to his power. We can understand the are part. We either know that someone is subject to your power or they are not. When he says are supposed to be subject to his power, we are not quite sure what he means by that. When he says supposed to be, is it moral ought? Or are we to assume, okay, when there is lack of clarity about the fact, that we are to assume that he is, that one is subject to the power of the sovereign. So there's another part. I don't want to go into all that, but this part should make it quite clear. So there are certain parts of this definition of a law. You need an assemblage of signs, okay, not just one sign here and there, okay, here, but there are assemblages of signs, okay, that declare the will, either conceived or adopted by the sovereign, okay, regarding what? Regarding the conduct to be observed, okay, when, in a certain case, by who? By a class of persons, okay, and these class of persons are supposed to be subject to the will of the sovereign. Now later on Austin also talks about the idea of sovereign, okay. He says that law is the command of the sovereign. So you see that idea was already there in Bentham's work. So he should rightly be credited as the father of this specific kind of jurisprudence, positive jurisprudence. So he then identifies 4 different elements of a law that he is talking about. There are 4 elements that Bentham identifies, okay. Those 4 elements are important in law. Again, something that you see in positive law, okay. What are those? Says law is the product of sovereign's will, okay. Law is not just anything, okay. It is product of sovereign's will, and that's why he does not think that what judges do is law, because judges are not sovereign, okay. So law has to be product of sovereign's will. And such a product, okay, such a product, that is the law, is made known to citizens and officials in the state. So before you are bound by a particular law, before your conduct is subject to a particular law, you should know what the law is. So that idea of prospectivity that I was telling you has to be there. So that's the second element, that such a product, okay, that is the law, which is the command of the product of the sovereign's will, not command, he didn't say command, okay, is made known to the citizens and officials in the state. So it has to be proclaimed, okay, it has to be published, whatever, okay, made known to the citizens and officials in the state. And then this law lays down certain courses of action, okay, or demands restraints from action. So law could function essentially in 2 different ways, but then there are other ways that he talks about, okay. How does it work? So it lays down certain courses of action. So what you are to do, okay, that you should do this, okay, or do not do this, okay. So it could either take the form of action, or it could say that do not do. So it's expecting restraint from you, okay. And ultimately, okay, a very integral element of law, as is the case with many positivists, is the use of sanction, okay. If you had just the first part, that is sovereign's will, okay, but what's the worth of sovereign's will? What if no one cares, okay? So you need this bit, okay, it's very important, and it is the use of sanction. So sanction in his theory, okay, is a very integral part of the idea of law that he is talking about. So he identifies 4 different elements, okay. Sovereign's will, that it has to be made known to the citizens and officials, okay. And what does it do? It lays certain courses of action or demands restraint, and then ultimately if you do not do or do something that you have been asked to do or not do, then consequence will be use of sanction, okay. So this consequence is very integral part of the law that Bentham is talking about. This is something that you will see other positivists like H.L. Hart disagreeing with, okay. We'll see why. Or he doesn't give much importance to the element of sanction as much these thinkers do. So for Bentham, okay, unlike the other next philosopher that we are going to discuss, okay, as I said, Austin says law is the command of the sovereign. In Bentham's definition, you see that he hasn't used the word command, so it's a much more detailed and much more complicated definition than what Austin says. So there are certain elements of this sovereign will, and it does not merely take the form of command. It does take the form of command now and then, but it could also be in other forms. So command is when you are asked to do something. So it could also take command in the negative sense of the term, take the form command in the negative sense of the term. And what is that? Prohibition. So you are asked to do, or you are prohibited from doing something. But then command could be positive, negative, but then that's not it. Law could also take sovereign's will. Okay, here could also take other forms. Okay, what are those? So quite often law leaves it up to you, okay, to either act or to forbear. Okay, so what are those? Those are essentially permissions. Okay, when law gives you permission, it does not directly tell you to do this or that, or to not do this or that. It can also permit you to do something which is otherwise not permitted, or it could also permit you to not do something which you are otherwise compelled to do. Okay, so these are the other forms, okay, that this idea of law, okay, that is sovereign's will, could take. Okay, so I hope you guys are with me. Am I clear to you guys so far?
Yes, sir.
Okay, what about the rest?
Yes, sir.
Yes,
Sir, can you repeat
Yes, sir.
the part about the permissions?
Yes, sir.
So I told you guys that the problem is that we have not yet discussed Austin. That's why a little difficult, but then because we are going in a chronological way, so I'm referring to Austin now and then. Okay, so Austin's definition of law is that law is the command of the sovereign. Okay, so this sovereign's will that Bentham is talking about, for Austin it is only in the form of command. Okay, let us assume that when he says command, he's also talking about prohibition, in the sense that when you are commanded to do something, you do something. When you are commanded not to do something, which we also know as prohibition, is basically command to not do something. So that part is quite okay with both the philosophers. But in Bentham's definition, in addition to command and prohibition, there is something called permission. Okay, so for example, when I permit you to submit your project late, okay, what am I doing here? You are otherwise, in the absence of that permission, okay, you are to submit it within certain time. Okay, but if I allow you, if I permit you to submit a little late, in such case I am giving you a choice to do the same act but little later. Now this choice you do not have, okay, unless I give you that permission. So that's what it is. So it could take two different forms, as I told you. So it could be in the form of, for example, permission to act. Okay. So for example, you are not allowed to enter my property. So you do not have that permission there. But once I permit you to enter my property, you now have the liberty to either enter my property or not enter my property. You still have the choice. If I merely permit you, you have liberty to enter my property or not enter my property. So this is a better example than the previous one I gave, because then, so I hope you guys understood. Something that you have a choice in, okay, so the element of liberty that is created in your favor cannot be seen in the works of John Austin. For that matter, even power, okay, power, the case of power. So when I give you power through a particular legislation, now you have the capacity to change someone else's legal relation. Okay, so for example, if you have a property, piece of landed property, you have the power to sell it. Okay, no law says that. Okay, so for example, the general law of property does not say that you shall transfer this property. It does not do that. It merely gives you the power to either sell it or not sell it. The choice is yours. Okay, now those cases of power or those cases of liberty, okay, does not fit into the definition given by Austin, but that very much fits into the definition, so far as we understood, of the one that is given by Bentham. So he says permission to forbear. So when he says permission to forbear, so you otherwise have a duty to act in a certain way. Okay, otherwise there is a command to you to act in a certain way, but in this instance you have been permitted to forbear. Okay, but you could either do or you could forbear. So the choice is still yours. So when I say permission, it's in the nature of either liberty or some kind of power here. Okay, and permission to act, I need not explain. It's the same. Okay, you otherwise do not have the duty to do it, but now that you have been given permission, you could either act or you may not act. So I hope you guys understood the third aspect that our philosopher here develops. Is that clear? Jairaj?
Yes, sir.
Okay.
Yes, sir.
Okay, so yes, so this is a very important development, okay, that had happened before Austin's work. But anyway, so that's the sophistication that you see in his work, okay. So I hope you guys understood. So now his definition has, okay, certain very specific features that we need to deal with, okay. So let's deal with the different features of the definition of, of definition of law that he gives, okay. So what is the source of law, okay? So now I'm talking about source here. I'm not talking about it being either legislation, custom, precedent. No. For Bentham, where does law, arise from? Where does it emerge from? Okay. So as you know, his definition says that it's the expression of sovereign's volition, isn't it? So volition is will. So what is the source of law for Bentham then? So the source of law is the expression of the will of a sovereign within a state. Okay, so you need state. Within that there is something called sovereign, whatever that is. Okay, when that sovereign expresses its will, okay, not just any expression though, it has to take some kind of legislative form, okay, not any other, okay. But here's a problem that emerges, okay. How do we know, okay, so which one exactly takes legislative form, which expression of will takes the legislative form? That for Bentham varies from one legal system to another legal system. So for example, he was in England, so there any expression of will, even the one is very particular, as in it's directive towards one individual. Even in those cases, he says that it's an expression of sovereign's will, and hence it's something called law. So it takes kind of legislative form there. Whereas in France, the same is not the case, because that's not considered as a kind of legislation there, okay. So it seems that his idea of definition of law that he gives is not universal, it's descriptive of legal system. So there is a kind of confusion there. That's in fact one of the criticisms, if you remember, some of the our philosopher John Finnis talks about, okay, that these definitions that they talk about, these philosophers talk about, are merely descriptive of a particular legal system. So maybe in our case it's descriptive of one particular legal system that Bentham is part of. But the problem with this definition is that it is not merely giving you a description of what English legal system is like and what laws are there in English legal system, but he's also telling you what the law should be. So that's where the problem is. Anyway, so we know that he says that apart from all the confusions, that what is a law, what is the source of law? It is, you find the law in the expression of will of the sovereign, okay, within a state, but it has to take a legislative form, okay. So the presence of state is very important, okay. The superstructure of state is indispensable for the kind of law that he is talking about. So he says a society that lacks the superstructure of a state has no sovereign and has no law in the sense that he is talking about law, okay. So in the sense that Bentham is talking about law, there has to be a state, the superstructure of the state, and if there is a state, then there is something called sovereign, and there is something called sovereign, then there is law in the Benthamite sense, okay. Now let's look at what his understanding of sovereign then, okay. What is a sovereign? So he says, well, he's not referring to any monarch. So for example, in the sense Hobbes was probably referring to, he's not referring to that absolute sort of monarch, okay. His idea of sovereign is quite fluid. So it could be either a person, okay, it could be any person, or it could be assemblage of persons, okay, to whose will the a whole political community are supposed to be in disposition to pay obedience, okay. So here's the thing, okay, you find little more clarity of the definition of sovereign given by Austin. But before we go there, let's look at what Bentham says, and you know that Austin had developed his theory based on what Bentham says. So let's look at what Bentham says. So he says sovereign could be either any person, so it could be individual, or so a tyrant could also as much be a sovereign, or it could be an assemblage of persons. Okay, who are they then? Okay, so and what happens once they are there? So their will matters, because their expression of will is the law. Okay, so to whose will, okay, an entire political community either are, okay, in disposition to pay obedience. So it is likely that this entire political community will pay obedience, or are supposed to be in obedience. Now, as I told you, we do not know what exactly to mean by the word supposed to. Is he using it in the moral sense? Then I think that's not a very positive definition, a fact positive definition. And we know pretty sure that they are not one of the normative jurisprudence, but then it seems there is an element of norm here, but we are not quite sure what he really means. Let's assume that he says that we are observing a particular state, okay, where there is a person or assemblage of persons, okay, who express their will, okay, and the political community there are in the disposition of paying obedience. If that is the case, then the person to whose will the political community is subject to is in fact the sovereign. Okay, and how do we know then who is the sovereign? I think that's an empirical question then. Okay, who do people subject their will to? Okay, who do people the entire political community? Okay, he says whole political community, okay, pay their habitual obedience to. I'm using habitual, that's not there in Bentham's definition, sorry, that's there in Austin's definition. But nonetheless, for us, how do we know? We know from the empirical fact. So I am subjected to the will of the legislations, okay, to the expression of will in the form of legislation enacted by those who are in the parliament, okay. So that's the idea of sovereign. But then problem arises in case of federation. I'm not going into all these political science questions at this stage, but for now just be satisfied with this much, okay. So that's the idea of sovereign that he is talking about, okay. And you know that political society is also important, okay, because it is in this society that this entire thing happens, okay. So political society is very important. Political society is the state, okay. So he says that you need state, you need sovereign, and without that there is no law, okay. Now what is a political society then? Okay, so he says the unity of civil society is not constituted by a set of rules that all members are obliged to observe, but by a habit of paying obedience to a person or an assemblage of persons of a known and certain description, those who possess such habit, together with those who they obey, in a state of political society. A very complicated definition, isn't it? So what's a political definition? Okay, it's not an outcome of a set of rules, okay, that's not enough, okay, for them, okay. So it's an empirical reality, as I told you, okay. How do we know that? So there is a person or set of persons, okay, and there is a group of persons, okay, who are in the habit of paying their obedience to, okay. So from that only you are able to find out whether there is a political society or not, okay. So he says those who possess such habits, okay, so those who subject themselves to the will, okay, together those who express their will together with those who obey, okay, those who subject themselves to such a will, together the whole thing is the political society. So it's a holistic definition. You do not just look at from those who direct their will, but you also look at those who receive their will. Now that is very important in this definition that Bentham talks about, in the sense that the idea of law, okay, is not unidirectional, okay. If there is a one directional expression of will, there should be from the other side a reception of that will as well, in the sense that people subject themselves to the will of the sovereign, okay. So that's a very important aspect of the definition that has been given by Bentham here. Now is this idea of sovereign that Bentham is talking about, okay, You will see in Austin's definition later on that the idea of sovereign that Austin talks about is kind of absolute, okay? So because the sovereign is not in the habit of paying obedience to a like superior in the definition of Austin, so there is no legal limitation on, sovereign, okay? So is the idea of sovereign absolute in Benthamite definition? It appears so. It appears that so far as we understood from having read the definition that Bentham talks about, he's saying that you need a superior, okay? There is someone, okay? He's not saying that it's superior, but most people do subject themselves to the expression of the will. And then sanction is also important in his definition. So it seems that there is a kind of superior-inferior relation here. But then we also see that in Bentham's definition, there is also this aspect of not merely directing towards inferior, but also reception by those who obey. So what can we learn from that aspect of the definition of the sovereign given by Bentham? So probably not in Bentham's definition, although its sovereign is the sovereign is quite absolute, but it's probably not as absolute as Austin says, okay? So there is a way to limit the sovereign, okay? So in the definition given by Bentham, so there could be certain transcendental rules, in the sense that certain rules to which even the sovereign is subject to, okay? So that is quite possible, okay? And but then problem is that what if the sovereign does not will to subject himself to the transcendental rule? Well, again, it's a practical question, isn't it? It's a practical question. So quite often you will see that whenever there's a tyrant who overlooks the constitutional limits on what powers he or she can exercise, society has its way of being done with that, and then eventually they do overthrow the same. But then Bentham is not talking about it in that sense. He's talking about possibility of certain transcendental rules in the form of constitutional limitations. Okay. But does it fit into the definition of sovereign? That's a moot question. Then another important question is there a legally limited sovereign, in the sense that what if there are two sovereigns, okay? They promise to one another that this is what we will do, okay? So if there is a pact between two sovereigns, okay, known as pacta regalia, could that act as a limit on sovereign's power? I think today we have overshot the limit of our class. So in the next class we will discuss on this, okay, if in his definition the same said idea is possible or not. With that we end our discussion for today. So